Section 702 of FISA is a law that allows the U.S. government to collect the electronic communications of foreigners overseas without a warrant, even if they communicate with Americans. This law was supposed to be used for foreign intelligence purposes only, but the FBI has abused it to spy on Americans without any judicial oversight. According to a report by the Brennan Center for Justice, in 2021 alone, the FBI conducted up to 3.4 million warrantless searches of Section 702 data to find Americans' information. This has turned Section 702 into something Congress never intended: a domestic spying tool. One of the most alarming examples of this abuse is how the FBI searched Section 702 data for information related to the Jan. 6, 2021 insurrection at the U.S. Capitol and racial justice protests in 2020 without a warrant or a foreign intelligence purpose. This was revealed by a ruling by the Foreign Intelligence Surveillance Court, FISC, that was made public in April. The FISC found that the FBI had repeatedly violated rules meant to protect Americans' privacy by conducting queries of Section 702 data without proper justification. Between mid-2019 and early 2020, FBI personnel searched for information about domestic terrorism, violent extremism, civil unrest, and other topics that had nothing to do with foreign intelligence or national security. The FISC also found that the FBI had failed to document the basis for these queries, as required by law. Moreover, the FBI had shared some of the results of these queries with other agencies and entities, potentially exposing Americans' private communications to unauthorized parties. Despite these serious violations, the FISC approved the FBI's continued use of Section 702 authority in November 2021, while ordering some reforms and oversight measures. However, these reforms were not enough to prevent further abuses, as shown by the dramatic decline in the number of U.S. person queries conducted by the FBI. In according to an annual report released by the Office of the Director of National Intelligence, ODNI, in April 2023, FBI searches of U.S. citizens' electronic data under Section 702 dropped from more than 3.4 million in 2021 to just over 204,000 in 2022, a decline of nearly 94%. The report attributed this reduction to changes in the FBI's systems, processes, and training relating to U.S. person queries. However, civil liberties advocates and lawmakers have argued that these changes are not enough to protect Americans' privacy and constitutional rights. They have called for a ban on warrantless backdoor searches, which allow the FBI to query and use Section 702 data in routine criminal investigations entirely unrelated to national security. They have also urged Congress to enact more safeguards and reforms to Section 702, which is due to expire at the end of this year. Without additional safeguards, they say, a clean reauthorization of Section 702 is a non-starter. The FBI's warrantless searches of Americans' data collected by the NSA under Section 702 of the Foreign Intelligence Surveillance Act, FISA, have been repeatedly found to violate the law and the Fourth Amendment by the Foreign Intelligence Surveillance Court, FISC, which oversees the program. Section 702 allows the government to collect the communications of foreigners abroad who are targeted for intelligence purposes, even when they are talking with or about Americans. The FBI can query this data using the names or other identifiers of Americans, but only when there is a reasonable belief that the query will return foreign intelligence information or evidence of a crime. However, the FISC has uncovered numerous instances where the FBI violated this standard and searched for information about Americans without proper justification. For example, in 2019, the court revealed that the FBI had conducted tens of thousands of improper searches of raw intelligence databases from 2017 to 2018, affecting an unknown number of Americans. In 2020, the court disclosed that the FBI had misused the program to search for information about hundreds of Americans who came under scrutiny in connection with two politically charged episodes of civil unrest: the protests after the 2020 police killing of George Floyd and the Jan. 6, 2021 attack on the Capitol. In both cases, the court found that the FBI had failed to comply with the querying rules and had violated the Fourth Amendment, which protects against unreasonable searches and seizures. The court also criticized the FBI for not reporting these violations in a timely manner and for not taking adequate steps to prevent them from recurring. As a result, the court ordered corrective measures, such as requiring more training and oversight for FBI personnel, limiting access to Section 702 data, and imposing stricter documentation and review requirements for queries involving Americans. The court also warned that it may impose further restrictions or sanctions if the FBI does not substantially improve its compliance. The court's rulings have raised serious concerns about the privacy rights of Americans and the accountability of the FBI. Critics of Section 702 have argued that it enables mass surveillance without meaningful safeguards and that it should be reformed or repealed. Supporters of Section 702 have defended it as a vital tool for national security and counterterrorism and have claimed that the violations were unintentional and isolated. The debate over Section 702 is likely to intensify as Congress faces a decision on whether to renew it before it expires in December. The Biden administration has expressed support for reauthorizing it without changes, while some lawmakers have called for more reforms or oversight. The fate of Section 702 will have significant implications for the balance between privacy and security in the digital age. The FBI's violations of the Section 702 program could have serious implications for the congressional reauthorization of the program, which expires at the end of 2023, and the public trust in the FBI's use of surveillance powers. Here are some of the possible consequences. The violations could undermine the FBI's credibility and legitimacy in the eyes of the public and the courts. The FBI has repeatedly failed to follow its own standards and procedures when querying the Section 702 database for information related to domestic matters, such as the Jan. 6 insurrection and the racial justice protests in the FBI also failed to keep a record of each U.S. person query term used for a query, as required by law. These breaches of privacy and accountability could erode the confidence and cooperation of the American people and the judicial system in the FBI's mission and authority. The violations could jeopardize the reauthorization of the Section 702 program by Congress. The program is a vital tool for counterterrorism, espionage, and international cybercrime investigations, according to the FBI and other intelligence agencies. However, the program has also faced criticism and opposition from civil liberties advocates and some lawmakers, who have raised concerns about unjustified searches of Americans' communications, potential abuses of surveillance powers, and lack of oversight and transparency. The revelations of the FBI's violations could fuel these arguments and increase the pressure on Congress to reform or restrict the program, or even let it expire. The violations could affect the legal challenges and litigation involving the Section 702 program. The program has been challenged in several lawsuits by civil rights groups, journalists, lawyers, and others who claim that their communications have been unlawfully collected and searched under Section. The courts have largely deferred to the executive branch on matters of national security and foreign intelligence, and have upheld the constitutionality of the program. However, the disclosure of the FBI's violations could provide new evidence and arguments for the plaintiffs to challenge the legality and validity of the program, and to seek remedies for their alleged injuries.